All right, so hello everyone, and welcome to this second seminar for Law 8712, Comparative Constitutional Law. So this seminar basically will take us through some feedback on your first assignment and some hints on the second assignment. I will cover some material from your handbook, but always really trying to give you hints into how you use that material into the second assignment. I don't envisage to have 2 hours for today, so probably it's going to be within the hour, so hopefully we'll finish before 2 o'clock. Again, my contact details, if you need to email me in relation to the second assignment or any questions you have about the topic or the course. You can have appointments as well, and the phone number, of course, for urgent matters. Just another reminder that later this year, in June, we're going to have this World Congress for constitutional law, and there's huge emphasis there on comparative constitutional law. Actually, this is about Tom Ginsburg's project first. If you have been to this website, you'll find that there are a lot of useful indices for you to use in order to compare between constitutions. Now, that could come handy, especially in the second assignment. If you think that's the case, then great. Otherwise, don't worry about it. But have a look. See, just go to the website and look around, and you'll find that it's comprehensive in its treatment of world constitutions, at least on the national scale. That's the other one I was just talking about, which is the World Congress, and this is once every 4 years, and it brings in basically practitioners, academics, and judges from all over the world. And this time around it's going to be in Seoul. Last time it was in Norway, in Oslo, and it, as I said, happens only once every 4 years, so it's a big event. If you can attend or just keep an eye on that, watch that space, that would be great. Another one also happening this year in July, so just after the one in Seoul, is the World Congress, again once every 4 years, which is going to be on comparative constitutional law. So if that's also of interest to you, so just to know about. Okay, let's quickly just go through the assessments, just some feedback on the first assessments first. So as we know, there's no final exam in this course. You just have to submit 2 research, basically output, research monographs. The first is your direct research problem, which was basically based on 5 questions. So that gave you sort of a path or a third wheel, if you like, to help you, get to the final question in a way. In the second problem, which is also weighed the same thing, 50 marks, you don't have that, so you will have to think of how you want to structure your arguments based on the 2 pieces of information that are given to you to start you off on the question. As far as the first assignment is concerned, the range of marks was between a B, basically, and an HD. So the highest was an HD, and the lowest was a B. Not bad, but to be quite honest with you, most of the arguments were very conservative. I didn't see many people really venturing into at least imagining a different future, given what we have learned, or at least what you know about the Federation of Australia and its comparison to Canada and to the United States. The question that I was really very unhappy about is this idea of the relationship between federalism and subsidiarity. So what I saw was basically either people conflating the ideas of federalism and subsidiarity. Some basically were using it interchangeably, thinking that it's pretty much the same. Some of you thought that subsidiarity is more about decentralization. So they thought that it was actually just a substitute or synonym for decentralization. So that was the one that I really was unhappy with. Again, when we talked about subsidiarity as a constitutional principle in Australia and Canada, all of you actually said it's not mentioned basically by name, but the spirit or the gist of this concept, the sort of essence of the concept is there. Okay, but of course that doesn't help much since you haven't really explained what that essence is in the third question. So the fourth question was really still trying to flesh out what we needed to say in the third question. As far as the last question, that was the point about being adventurous or being different or being innovative, imagining different futures. No one thought really that Australia should have anything other than the status quo. So everyone thought that federalism is the best, and it has been implemented, you know, in a way that was appropriate for Australia in the past, and it will continue to be appropriate for Australia in the future. Although many of you, of course, at least some of you sort of struggled with the tension between, you know, the role of the national government, okay, and the idea of globalization, or even glocalization, which is a portmanteau for saying that it's global and local at the same time. You can Google it. Glocalization. And the thing is, the people who struggled with that still thought that, you know, the national government, whether it's in Australia or anywhere else, would still be very relevant in the future. Of course, this is happening just after we've heard about very exciting developments, I thought, in Spain in relation to Catalonia. Of course, this is still a work in progress. We still don't know what's that going to lead to eventually. But there are other also parties, you know, watching and waiting to see how that's going to unfold. In particular, in Scotland, people are still thinking of this idea of separation in a way, of secession. Not necessarily, of course, if we think about subsidiarity. That was really the intention, to see that there is another option, you know, another option for these regions rather than either federation. And of course, the federation then will lead us to think about what is then the subnational constitutional space that they are afforded or they are given under the Constitution. So that's really what you will be writing about in the second assignment. But anyways, you know, I thought that there was really more room for more innovative arguments there. All right. Let me then just briefly explain what I mean by subsidiarity with this picture, this photo. As you can see, this is what is known as Matryoshka dolls. They originally come from Japan. Sometimes they're called 7 gods of fortune dolls. And as you can see, these are nesting dolls, right? So usually they will all sit inside each other, and you will see only one, right? It's like an onion, basically. Now, what's then the difference between federalism and subsidiarity looking at this? Federalism, regardless of whichever constitution you look at, will almost always see only 2 of these dolls. In other words, it will see only the national or federal government, like the Commonwealth government, and it will see 1 level down, so the state governments. Okay, so in Australia we have the federal and state governments mentioned in the Constitution and afforded their rights under that Constitution. Now, under subsidiarity, you will find that there are more dolls, if you like. Okay, all right. So if you look at the Swiss Constitution, for example, I'm talking about the federal constitution, you'll find that it mentions more than just 2 levels of government. So they are recognized as levels of government constitution. And then that takes us definitely to the next question of this subnational constitutional space. Okay, so in federalism, the point to take home, you have only 2 governments. It's always going to be binary. It's going to be switch on and off. So you're trying basically to divide, okay, to divide powers, and I mean divide. You know, so it's either with this government or with that. The beautiful innovation that we see in the Australian Constitution, at least in theory, the High Court definitely was not buying into that argument, and they interpreted the Constitution in a very sort of archaic way, if you like. But again, it was within, two world wars and a very unstable century. But my point is that because of the way we structured our Constitution, especially around Section 51 and the powers there, they are shared powers. They are not divided. Okay? So at least in theory, that sharing, okay, allows you to have an ebb and flow kind of situation depending on the environment within which we are working. Basically things like globalization. Okay? And how that power should be shared at certain points in time. Okay? So the idea is that if you look at the American Constitution, it's actually divided. The powers that are divided, you can't actually go back and say we would actually give this power to a different level of government. Of course you can, but we're talking still how the Constitution was drafted. The same thing with Canada. There's very little overlap between the federal and provincial powers. So in my mind still, I think that Australia is the one that's best placed, at least with the Constitution that we have. And again, there are still new now arguments in relation to becoming a republic, republicanism again, and all of that, of course, with the nation building and being able to maybe even repatriate the Constitution and so on. But the point basically again is that this is how we need to understand subsidiarity. It's about sharing power rather than dividing power, and it actually envisages more than just two levels of government. Before we leave this slide, let's then look briefly at the difference between subsidiarity and decentralization. Because many of you thought, at least I felt, that they were just simply saying, look, there's no difference between the two. It's just a matter of saying subsidiarity is really decentralization. No, it's not. Okay? And what is the difference between the two? Now, let's look at the first difference now, and then we look at the discuss a little bit more the assignment, the second assignment. We will look at the second difference. At least these are the sort of salient ones. The first difference is this. When it comes to decentralization, they don't only see a limited number of doors, okay? So whatever number of doors you have, but in fact, instead they see an infinite number of doors, if that makes sense to you. So decentralization is an economic theory. It's a pure economic theory. And it says that you can keep dividing these governments or jurisdictions as many times as you want. In other words, the problem with that theory, which is of course a problem with economics generally, so it's an imperial critique if you like, is that it does not identify a characteristic scale, okay, a characteristic scale for where you want to place the decision making, at what level of government or at what level or at what scale. So in physics, for example, we know that there are certain constants, like the Planck, for example, length, or the speed of light, that give you a divide between different theories and where they apply, like Newtonian physics versus, say, relativistic or quantum physics. So there's a characteristic scale, okay? But when you talk about decentralization, because it's a pure economic theory, it doesn't understand that. It doesn't see a characteristic scale. It cannot identify for us where we should place the decision making for a certain area, for a certain competence, based on the governments identified or recognized in the Constitution. So federalism basically is a subset of subsidiarity, and subsidiarity is a subset of decentralization. That doesn't mean, of course, that maybe I should refine that a little bit. Subsidiarity has an overlap with decentralization in the sense that they are both economic theories. Subsidiarity, however, is not a pure economic theory in that it also has an ethical dimension, or if you like, a cultural dimension. And that cultural dimension, so history, for example, or ethnicities, for example, like in Quebec, okay, versus the rest of Canada. That kind of calculus is going to give you this characteristic scale that identifies what's the optimal scale or level of government for where you want to embed that decision making. Federalism, however, sees only two governments, while subsidiarity can see more, but always a finite number of governments based on this ethical or historical sort of understanding or calculus or approach. Decentralization, on the other hand, has no characteristic scale. It can divide these governments as many times as you want, but it still cannot tell you where the best level for decision making is going to be. And if you go through it in detail, you'll find that then that would give you what's called a corner solution. Okay, so that means it's going to be either the individual, which is the very bottom of that infinitely many different levels of jurisdictions or levels of government or decision making, or it can give you the other corner solution, which is the national government. Okay, so if you focus only on the decentralization, it cannot really see anything in between, although it sees everything in between, because there are so many of them, infinitely many. Usually the final answer that you will get for any question of where this kind of law should be decided, it would either be at the individual level or at the highest level, which is the national level. Okay, let's leave that there. Let's start then talking a little bit about our assignment for today. And I just want to start by looking at this probably a little bit difficult or strange sort of alphabet. And this is a language that you will find spoken in countries in Northern Africa. Okay? It's called Tamazight. Sometimes called Tamazigh or Berber language. But basically this is a language that's ancient, that takes its alphabet basically from ancient Egyptian hieroglyphics. And it's making a comeback now in a number of countries in North Africa, so including places like Morocco and Algeria and Tunisia and Mauritania, Mali, even Egypt and Libya even. And how is this then relevant to what I want to talk about in relation to the second assignment? Note that none of these countries I've just mentioned are federal in terms of their constitution. Okay, so they are unitary states. Okay. However, because I always emphasize subsidiarity rather than federalism, you'll find that there's still a constitutional or a subnational constitutional space, okay, for different groups or different entities within this polity, okay, to carry out or to receive or to obtain their or some constitutional, for example, rights. Okay, and of course the one we're talking about here is whether this language could become an official language in the sense that it could be in fact taught in schools and becomes mandatory for people to learn and to understand. Okay. Now this is something you could probably link to the recent discussions we had here in Australia in relation to recognition of Aboriginal people, and how that also defines what we could refer to as subnational constitutional space. So when we talk about subnational constitutional space, it doesn't necessarily refer only to federal polities, but it also be unitary. And the most important thing here is that unlike federalism, subsidiarity would straddle both types of polities. You could have subsidiarity in a unitary state, just like they have it, for example, in Poland, where this idea, the subsidiarity principle, is recognized explicitly in their constitution. Or, of course, it could be the variety that we see in the federal polities. Okay. So what are we going to do for the second assignment? Some of you have picked up on the fact that on SciDesk it says some of the readings for week 2, because previous versions of this course actually gave you the readings, but then I thought this is a research course, so it would be just fair for me to just leave it to you to find these readings, and of course many more. But it says basically, it talks about 2 readings. The first says Australian comparative constitutional law expert Cheryl Saunders noted in 2000 that a revival, so this is 17 years ago, okay? A revival of interest in state constitutions in Australia would be consistent with developments elsewhere in the world. It's good to go back and look at this reading now, because we can ascertain whether in fact there was such interest, and if there was such interest, whether that was picked up on here in Australia, and if so, how did that then affect what we will refer to as the subnational constitutional space. Okay. Now, Christopher, I can see that you have a camera there. Did you want to say anything?
No, sorry, I just pressed the wrong button.
No, that's fine then. Cheers. Okay, so that's our first reading. The second reading then comes from Robert Williams, and Robert Williams is in fact one of the pioneers, okay, of a, if you like, a scholarly movement that started in the World Congress that I referred to earlier, that will be held later this year in Seoul. This is the International Association for Constitutional Law, and Robert Williams is a retired professor that used to teach in the States, the United States and Pennsylvania. Okay, and a more recent article there still talks about teaching and researching subnational constitutional law. Now, if you look at the Tom Ginsburg website, you'll find that I said it's quite comprehensive, but he doesn't really have any analysis of any subnational constitutions. So all of that project is really exclusively towards the national constitutions, right? And I've met with Tom quite a number of times, and we had discussions in Chicago, in his office there, and you know, you always ask, you know, when is the next phase going to come? You know, when are you going to expand this project now to sort of cover the subnational constitutions there? And for him, it's just a nightmare, and quite frankly, there's not enough funding to be able to expand that project in the foreseeable future, I'd say. However, that wouldn't stop us really from being able to look at some of the constitutions. So some of you have sent emails saying, oh, I want to look at the constitutions of sort of Australia, Canada, and the US, and that's perfectly fine. In fact, that's a very good, I would say, combination for you to continue with what you have done in the first assignment. It will not be held against you. So if you want to go ahead and use those 2 jurisdictions plus plus Canada, plus Australia, rather, that's perfectly fine. Okay, let's just look quickly at what Williams says. So he says, we contend that a careful study of the subnational constitutions of component units, okay, must proceed first from a top-down or center periphery view, okay, to determine the quantity and quality of subnational constitutional space that's permitted by the national constitution of the component units. Okay, so if this is Australia, the national, of course, constitution would be the Commonwealth Constitution, and the component units would be the states. Now he's here talking about a careful study. Okay, so pretty much what you will have to do in your assignment. But I want to also unpack a little bit what he's saying there in terms of top-down. You remember when we looked at the Matryoshka dolls, and I said I wanted to use that photo to explain a little bit the difference between federalism and subsidiarity. Well, here comes the second difference that I want to emphasize. Okay, Of course, here, Williams is simply talking about studying subnational constitutions. But his approach is pretty much a federalist approach. So he wants to look at the study of these subnational constitutional spaces in terms really of federalism, which is justifiable because that's really what we have in the United States. Although some of you said, oh, we have, of course, the subsidiarity principle there, at least in spirit. But if you look at the design of their constitution, which is the oldest constitution out of all three, if you're looking at Australia, Canada, and United States, you'll find that at that point in its evolution, the design itself was very much a divide. It was simply, this is for the states, and this is for the federal government. But there's also another reason, not just because it was the first, but it also was, so it's not really necessarily a deficit, you know, in how they designed their constitution, so they didn't know any better, and it was just the first prototype. No. It also means, the reason for that is also that these subnational units or components were, for all practical purposes, sovereign. Sovereign. We can compare these to the national, the constituent or component units in Canada and later on in Australia. We can't say the same, right? So that tells you then what is the essence of subsidiarity. Okay? Subsidiarity is not necessarily about sovereignty. Okay? Subsidiarity, again, is about really optimization from being an economic theory, just like decentralization. But it's also an ethical standard. When we talk about sovereignty, ethics doesn't play much role in there, usually. When you start talking about subsidiarity, because you'll find that really the origins, at least the more recent origins, come from Catholic social teachings, and even in Protestantism or Calvinism, it comes from, you know, what they call there the sphere of sovereignty. But even further back, you can trace it all the way to the origins of the Jewish religion, of Judaism. So there is more to it than simply saying that it's going to be a top-down study of this subnational constitutional space. Of course, that top-down approach would be the most relevant one if you're looking at unitary states, because we said unitary states would still have pockets, at least, or niches of such constitutional space within which certain groups, including even civil society, would be able to operate. If you don't believe me, you can go back and trace how what's known as the Arab Spring came about. But that's not really the emphasis here. My emphasis is on the second difference between federalism and subsidiarity. And the second difference is that federalism is definitely a top-down approach. So this subnational constitutional space in a federalist discourse, not necessarily in a federalist polity, but if the researcher or the scholar is adopting that idea of federalism as the compass within which they are going to focus or apply their lenses to this subnational constitutional space, they will see a top-down approach. So who creates this subnational constitutional space? It's created by the national government. It's created by the national constitution, and it's vested in this national government. So it's something like a managerial, if you like, delegation. The subnational space itself is going to be more of a delegation towards managing decision-making rather than independent decision-making per se. And that's definitely the approach you'll see in almost all environmental law or ecological decision-making almost across the whole world. With, of course, exceptions in new designs. For example, if you look at Bolivia or you look at Ecuador, because now they talk about multinational constitutions, so they're affording their First Nations or indigenous population a wider margin, or let me just call it subnational constitutional space, for them to operate within which and sort of vest this decision making in terms of environmental law in those levels of government. So federalism is top down and subsidiarity is bottom up. Okay? Remember that subsidiarity always talks about locating the decision making in the lowest possible level of government, closest to the people who are going to be affected by that decision, as long as, of course, as that level of government is competent to actually take that decision, okay, or to make that decision. Let's talk about competency a little bit and look at the second sentence. This would involve a determination of legal or de jure questions concerning the competency of component units to enact their own constitutions. Now, enact their own constitutions in this sense doesn't mean that they have a constitution or not. The question is not whether in Australia the states have the right to make their own constitutions. They got that way back, even from the Imperial Laws Validity Act, I think, of 1865, or even earlier. Actually, that act gave them the right to amend their constitutions. No, what we're talking about here is not whether they do have one or not. What we're talking about here is how they can evolve these constitutions towards those competencies. So I want you to think about how these states, whether it's or the provinces in Canada, how they actually can evolve over time. So again, looking back again at that subsidiarity discourse. So are you looking at a static process where there's division of powers and that's the end of it? Or are you looking at a subnational constitutional space that's elastic or dynamic? So it can actually envisage ebbs and flows in what is possible for these component units to perform or to do. Okay, let's then look at the third sentence. We suggest that this space would be either wider or narrower, depending on the range of discretion the national constitution provided for component units to adopt their own constitutions. And again, when we say adopt their own constitutions, we are meaning in being able to evolve their competencies. It's not just simply that you can create your own constitution. For example, if you look at the constitution for Victoria, it's even larger than the one for the Commonwealth, okay? And that's back from 1975, with amendments, of course. But my point is that they have constitutions. We all know that. That's not the starting point nor the end point, okay? What you need to go to is to see how these constitutions are given, or so basically whether this space, again, can be either wider or narrower, okay, depending on this discretion in the national constitution. So you want to look at Australia, for example, Canada and the United States, and see how the space there is wide or narrow, or can be actually elastic. So it's not just necessarily wide or narrow, but could also change over time, and depending on what discretion you can see in the national constitution. All right. Okay, so we can choose any countries you like from this list. Of course, you will have to have Australia. If you are an LLB student, again, the same story as from the first assignment, you need to choose only one more country. And if you are a JD student, you need to choose two. I would recommend, if you are an LLB student, to choose the United States. if you are a JD student, just go ahead and use United States and Canada. If there are, if you have certain sort of interests in the other countries like Germany, Austria, and Switzerland, you're more than welcome to look at those as well. But remember that the designs of those constitutions have very different traditions, very different pedigree. So in that sense, the comparison between them and what we have here in Australia is going to be at least that much harder, except maybe with Switzerland. Okay, so Switzerland was quite influential. Well, it was influential at least in the constitutional conventions. And if you go back and read the conventions, you'll find that there were quite a number of references to the Swiss federal constitution, and especially in terms, for example, of referenda and the ability to amend the constitution and so on. Okay. Let me just use another maybe 10 minutes or so, 10, 15 minutes to just say a few other things that you might find useful or not in terms of how you want to approach this assignment. In the previous seminar, we talked about the question of what is a constitution. And I need you to go back and ask yourself that question for this assignment. What is a constitution? And how do these constitutions differ, especially over time? If it's an ancient constitution versus, for example, a modern constitution, so after the revolutions in America and in France. So there are different objectives, as you can see on this slide, between them. Okay. So the bottom line is that originally a constitution did not have a normative signal. Okay? Constitutions were simply describing maybe the territory or the people or the religion or whatever. But it wasn't normative. So there was no expectations of what you should have or what a component unit should do. Okay? All right. So remember, this started all with the American Constitution. All right. So we have basically at the bottom of this slide says the connection between the modern Constitution and American and French revolutions, what we call the constituent power. Okay. Some of you picked up on this point when they compared at least the preambles of the three constitutions, if you are a JD student, between Australia, Canada, and the United States, and they found that our design, which is the more recent one out of the three, picked up on those points in relation to talking about the federal structures, but also talking about the people. And in that sense, we have actually at least picked up on more than one scale for decision making, at least implicitly. At least more than two scales of decision making, but basically the constituent power is the people. Okay? And then you have to ask yourself, who are these people? When you look at the subnational constitutional space and you look at the different components, look at the people as defined within a state, and then the people as defined within the Commonwealth. And how does that change our definition of the constituent power? And then how then that constituent power would project itself differently in different jurisdictions. We have just celebrated 500 years of Reformation as well. So again, the Reformation was to move to a social contract rather than a religious one. Okay. And the law became irreducibly positive. Okay, so law as the product of political will rather than religion. So the key point, look again at what we mean by constitution. Be very clear on what we mean by constitution. All right. So the key point again is that we moved from description to prescription, or from describing to a normative signal. And at the bottom there, again, constitutionalism, or if you like, the projection of this idea of rule of law as it applies to constitutional law, does not mean legislation of public power. Okay? So you could come up with a constitution, or you could find a constitution that's full of legislation of public power. Yeah, who should do what, and what should happen here, and which level of government is competent in this field, and so on. All of that is a legislation of public power. But none of that necessarily means constitutionalism. So how is constitutional relevant here? Constitutionalism? Because we're talking about these ideas of top-down and bottom-up, and we're talking about affording subnational components of this polity their subnational constitutional space. So think of it as rule of law applying to not individuals, but to entities or components of polities as if they were legal persons. Okay. So let's go back and talk about sovereignty. So a reminder again that sovereignty, at least in this tradition after the revolutions in America and in France, by proclaiming, it says that by proclaiming that the people are the sovereign, okay, constitutions assert their democratic legitimacy. A great number of constitutional documents include such proclamations. They do not serve a purely rhetorical purpose, and courts make abundant use of such provisions as important arguments. Okay. So again, this idea of how sovereignty changes, if you like, under subsidiarity versus federalism, and how that all links to this constituent power. And remember that the constituent power flows, if you like, or threads the different levels of government within this polity. Okay, let's talk a little bit about secession and self-determination. Secession and self-determination. I promise I'll finish within the hour, but let's talk quickly about these two things. As you can see, secession is a constitutional right. Okay, so, and self-determination is an international right. And I want to drop in immediately the word globalization, or what you will read about in your handbook in certain places, what they refer to as the internationalization of constitutional law. There are two types of theories here, primary rights and remedial rights. I'll leave that to you to have a look at. I'll post everything as usual on SciDesk. But I want to go through this quote. It says, in an inversion of the historical tendency, and we might disagree with this writer, that saw federalism emerge from a process of unification, and this is particularly to you folks who said or agreed with the status quo in Australia, because I really want to challenge that, please. You know, I really want you to think outside that box. It says today the formula of political decentralization is mostly used to divide. That is, to contain centrifugal tendencies. You divide because we're talking about federalism, not about subsidiarity. And it contains centrifugal tendencies. So, like what? Like Catalonia, like Scotland, like Kurdistan. By providing subnational groups, what makes them into a group? Providing them with a high degree of autonomy. In sum, most federal constitutions today are not ordained to form a more perfect union. Okay? saying that the status quo in Australia in terms of federalism is going to simply continue as is, as before, as it was in the 21st century, or just imagining that the High Court is just going to continue doing this engineer's case textual approach forever, goes against the grain. Okay, at least we can see tendencies today where that is not going to work. Not because we are not homogeneous or because we have these subnational groups, and I'm not talking here about First Nations or the Aboriginal people of Australia. I'm simply talking about groups. Of course, in countries like Canada where they have Quebec, or in countries like the US where they have this pedigree of well, sovereignty before becoming federated, that might be a different issue. Okay. But all that we're saying here is that if you look at new federal constitutions, like for example the one maybe in Spain or even the one in Iraq, for example, and just recent federations, you'll find that they are looking more at affording these groups like Kurdistan more autonomy. Okay, so what are they doing today? They are loosening the ties to a union, okay, that has become unbearable to many. Thus, the idea that constitutions do not necessarily look to indestructible unions. Where did that come from? Can you see it somewhere in our constitution here in the Commonwealth? So, the idea that constitutions do not necessarily look to indestructible unions and that they may contain international or confederal elements seems to re-emerge in contemporary constitutionalism. So have a look at that. Think about how these things are working with or against each other. Let's just finish off then on something called constitutional identity. Identity. So here it says, inasmuch as constitutional identity transcends the mere fact of constitutionalism or content of a particular constitution, again, the words emerge. It emerges in the context of what? A dynamic process. So look back at what I said as far as the differences between federalism and subsidiarity. When we talk about federalism being a static process because you divide the powers between only two levels of government, while subsidiarity envisages that dynamic sort of change in a shared power depending on pragmatic considerations. So it emerges, the identity, the constitutional identity, which you I hope will link to this subnational constitution space, it emerges in the context of a dynamic process that must constantly weave together self-identity's two facets. What are they? Sameness and selfhood. What is that? So you go and read about it more. Sameness basically talks about looking back. So you're looking at similarities. And selfhood is basically looking forward, looking at differences. Or in other words, looking at evolution. The idea that you can become whatever you want to become. So look back at Catalonia, Scotland in that sense. Let's look at this again quickly, internationalization of constitutional law. It says a constitution may become a treaty or provide treaty-like functions between subunits of a state or between different ethnic groups within a state. What does that mean? When we talk about treaties, we talk about treaties that would be upheld or honored between states, i.e. national states. So this is back when we talk about the Peace of Westphalia and talk about the emergence of this nation state as the preferred level of organizing at least economic activity. Now what's happening today? Again, go back and look at globalization and the pressures that that's putting on countries, especially the idea that even small countries the size of Singapore, for example, okay, are now viable on an international scale, on an international stage. The second quote says, regionalization may be a better expression for the present constitutional convergence. Okay? Now this idea of convergence is also going to be helpful in your assignment when you look at the 3 different or 2 different jurisdictions you're going to be looking at in terms of that subnational constitutional space. Do you see any convergence? Okay, is it a static space? That's the most important thing for me. Is it static? Is it federal? Is it top-down? Or is it dynamic? Is it subsidiarity based? And is it evolving especially towards more convergence, i.e. similarity with other subnational constitutional spaces, with other comparable countries like us? So one way to describe that, instead of saying it's internationalization of constitutional law, we could also describe it as saying it is a regionalization of national constitutional law. Other words, it's actually pushing down the decision making towards regions or towards subnational units. And if that's true, then there would be in fact an elasticity in that space that's changing now from a narrow to a wider space. So all you need really is to pick on one piece of evidence, one area where that's evident in that jurisdiction, okay? In terms of how that space or decision making has actually changed from one level to another. Okay. Again, the Constitution, this is the other way around, the constitutionalization of public international law. So again, it says the classical dualist perspective. What do we mean by dualist? We say dualism is where you have domestic law and international law, and international law cannot become domestic law unless it's passed by the, so for example, the Commonwealth Parliament, and then once it is incorporated into our domestic or municipal law, it becomes municipal law or binding on Australia. That's the dualist. If you look at countries like Germany, you'll find that they have a monoist approach, which means what? Which means that if it's part of international law, then that, reasonably would be considered as part of German law, because the difference really is just a matter of time or a matter of process through which you will incorporate that international law within your own legal system. So the classical dualist perspective, i.e. the perspective we have in Australia, does not accept the argument in public international law according to which international law necessarily takes precedence over all domestic law, including state constitutions. Okay, so here it's really in a way a shield, not a sword, but the point is, again, is how does that international public or public international law affect this subnational constitutional space? Okay, we'll leave it there. That's my hour with you for today. And again, if you have any questions, I'm more than happy. The best way really to do that is just to email me first, and then we'll take it from there. Thank you so much, and talk to you soon.